The first speaker on our program is Professor Mark Neely. Mark was born in 1944 in Amarillo, Texas. He earned his undergraduate degree in American Studies at Yale University in 1966 and his PhD in history at the same school in 1973. Yale's graduate school would award him a Wilbur Cross Medal in 1995. From 1971 to 72, Neely was a visiting instructor at Iowa State University. In the latter year, he was named director of the Lincoln Museum in Fort Wayne, Indiana, a wonderful institution that is no longer with us. Its collection was divided between the local library and Indianapolis, a state museum. I think I've got that right, isn't that correct? He held that position for 20 years. In 1992, Dr. Neely was named the John Francis Bannon Professor of History and American Studies at St. Louis University, and in 1998, he was made the McCabe Greer Professor of the History of the Civil War Era at Pennsylvania State University. He is the author of the Pulitzer-Wise winning The Fate of Liberty, Abraham Lincoln and Civil Liberties, 1991, and among others, many others, The Civil War and the Limits of Destruction in 2007, and his most recent book is Lincoln and the Triumph of the Nation, Constitutional Conflict in the American Civil War, published in 2011. He is currently working on research and writing a book on the Democratic Party during the Civil War. So we welcome Professor Mark Neely.
War in America stimulates constitutional conflict. And, you know, it doesn't seem like it really should. It doesn't seem like the best time to be talking about constitutional fundamentals while war is going on, but that's the case. We know that now. Abraham Lincoln knew it when he entered the presidency. And one of the ways we know that he knew constitutional conflict was inevitable, was that he, in America's most recent war, before the Civil War, had done his part to stir up opposition to that war on constitutional grounds. Lincoln served as a Whig in the United States Congress during the Mexican-American War, 1846 to 1848. His term of service actually began on December 6, 1847. The Declaration of War had been made by the previous Congress. And the administration waging the war, of course, was headed by Democratic President James K. Polk. So in the Mexican-American War, then, the Whig Party, with Abraham Lincoln, played the role the Democratic Party was going to play during the Civil War when Lincoln was president. That is, the loyal opposition. Up to 1846, in the beginning of the war, Whigs, like Lincoln himself, had been much less concerned than Democrats to raise constitutional issues. To the degree that Whigs sought national economic development through projects with government support, they were naturally given to a broad construction of the Constitution. And nothing in the document expressly delegated to Congress the power to do what Whigs wanted it to do, and that is build canals and railroads and establish a national bank. So Lincoln was as economic development minded as any Whig in the entire country. And so he was therefore liberal in his interpretations of the Constitution. And if you want kind of something that typifies his outlook from this period, in one speech he said, "I have already said that no one who is satisfied of the expediency of making internal improvements needs to be much uneasy in his conscience about its constitutional. He had an easy conscience on the Constitution." until 1846. And then, when a war began under a Democratic administration, Lincoln and the other Whigs got to scrutinizing laws. And in fact, then, one of the very first things that Lincoln did as a congressman when he arrived in Congress, he arrived in December, and then one of the first things he did was on January 3rd, 1848, was to vote for a thing that was called the Action Amendment. And that amendment declared that the Mexican-American War was, quote, a war unnecessarily and unconstitutionally begun by the President of the United States. Quote. Now, I would like to say that this is a position that was taken by no Democrat during the Civil War. There were no Fort Sumter deniers, all right? The Civil War Democrats, many of them, argued that the first shots fired by the Confederates at Fort Sumter could have been avoided by political compromise, should have been avoided by political compromise, but they were not fired. All right? So Democrats argued that the war might have been and should have been avoided, but they knew that the war that was then being fought was not unconstitutional. Well, Lincoln himself had argued back in the Mexican-American War that it was unconstitutional, and that despite the fact that war had been declared by the United States Congress with only 14 Whigs in the House and 2 in the Senate opposed. Now, once Lincoln had declared the war was unconstitutional, Congress's law partner back in Springfield, William Herndon, who was also a Whig, right down to the ground, nevertheless wrote his law partner and complained. Now, we don't know exactly what the complaint was because the Herndon's letter doesn't survive, and all we have is Lincoln's answers. I'd like to know exactly what Herndon said, but we don't, so all we have to go on is the scolding letter that Lincoln wrote to his partner, straightening him out on the Constitution. All of a sudden, you'll notice, Abraham Lincoln, the broad-minded constitutionalist with an easy conscience about the Constitution, all of a sudden, he's raising objections on the score that he hadn't usually done in the past. Well, one thing we could ask of this is, did Lincoln in 1847 and 1848, did he have a constitutional leg to stand on? The Mexican-American War, as I said, was the war declared by Congress, so in a sense it couldn't be unconstitutional. But the circumstances of the declaration were tricky, to say the least. The Polk administration combined a declaration of war that said that war existed by the Act of Mexico, which had shed American blood on American soil, and they combined that declaration with an appropriation of $10 million to fight the war. They're all one measure. And so you might say to yourself, well, if the Whigs were opposed to the war, why didn't they go ahead and vote against the money for the war too, all at the same time? Well, that shows that you're not a congressman. And to understand them, you need to understand an important point. And that is that America had, still has, not only a written constitution, but an unwritten one. And part of the unwritten constitution was stemmed from the War of 1812. The Federalist Party, during the War of 1812, had made a very big mistake. And by 1846, everyone knew it and remembered it. The Federalists thought the War of 1812 was all wrong, that we ought to be fighting Napoleon, not helping him. And so they voted against appropriations to supply the troops in the field in that war. It didn't make a particle difference because they were in a tiny minority in the Congress and the troops were supplied anyway. That is, it didn't make any difference to fighting the war. It made a tremendous difference to the Federalist Party because in 1815, after the victory of the U.S. in the Battle of New Orleans and then the end of the war, the Federalists collapsed virtually overnight as a political party because they were regarded as traitors who didn't vote for supplies for the troops of the field in this great victorious war. So, American politicians never forgot that. They still haven't forgotten it. They learned this unwritten part of the United States Constitution governing war. You cannot vote against supplies for the soldiers once the troops are already in the field. Every politician in Congress knew that. Lincoln knew it when he was in Congress, and in fact later, in the famous campaign of Douglas in 1858, the Democrats scrounged around in Lincoln's record and thought they would raise against him the charge that he had voted against supplies in the Mexican War. He opposed the Mexican War. And an alarmed editor in Chicago wrote in and said, they're going to do this. Is there anything to it? He wrote back and said, don't worry. In fact, he said, quote, I have examined the journals a good deal, and besides, I cannot be mistaken, for I had my eyes always upon it. Always, he had his eyes. Well, James K. Polk and the Democrats knew the unwritten Constitution as well as they did the written one, so the Congressional Declaration of War then was combined with appropriations for the war. And to vote against the Declaration was to vote against the troops in the field because General Zachary Taylor had already suffered casualties in combat with Mexican forces near the Rio Grande. So both ways voted to declare war. Well, Lincoln hadn't arrived in Congress yet when the war declaration was made. And so by the time he came, he had kind of luxury of conscience. And so he told Herman in explaining his vote on the Ashland Amendment, quote, that vote affirms that the war was unnecessarily and unconstitutionally commenced by the President. And I will stake my life that if you had been in my place, you would have voted just as I did. Would you have voted what you felt you knew to be a lie? Well, what's at issue here? Well, the war declaration, as I said, stated that war existed by act of Mexico and American blood is shed by Mexicans on American soil who had crossed the Rio Grande to attack Zachary Taylor. The problem was, of course, that the boundary of Texas had never been settled by treaty. No one was quite sure where it was or how far beyond the Nueces River, between the Nueces River and the Rio Grande, how far beyond that actually Texas really extended. So Lincoln and the Whigs said that it lay somewhere between the Nueces and the Rio Grande, but it didn't extend all the way up to the Rio Grande. So the spot where American blood was shed was not American soil. And of course the Democrats said otherwise. And among the Democrats who said otherwise, incidentally, was Stephen Douglas. He had been in the Congress that declared war, and he defended the President Polk's position on it, and gave a long speech. And the central arguing point in his justification was that John Quincy Adams, who was sitting in the House, remember Adams, after he was president, went back to the House of Representatives, and he voted against the Mexican War. So he had voted against that declaration. But Stephen Douglas pointed out that when John Quincy Adams had been Secretary of State in 1819, he had said flatly, quote, our title as far as the Rio Grande was as clear as it was to New Orleans. Well, Adams is sitting right there and hearing this. So he replied that, well, back in 1819, when I was Secretary of State, and then I'll quote, he endeavored to make out the best case I could for my own country, as it was my duty. my first point then is simply this. Constitutional conflict is to be expected in American wars. And we might naively think that it's a bad time to argue about the Constitution, but that's the way it's always been. So the Democrats in the Civil War did not avoid constitutional agitation either. And then I'm going to talk now about one of the Democrats' objections on constitutional grounds to the way Lincoln fought the war, and that is conscription. And this now leads up to my supporting cast of characters today. In addition to Lincoln, I have obviously Roger B. Taney. But I want to introduce, if you don't know them already, two other people who are not as prominent in constitutional history, Joseph Medill and Dennis Mahoney. They come later. First, Lincoln and Taney. Now, Roger B. Taney, who was the Chief Justice of the United States Supreme Court, was, like all the other Democrats, scrutinizing the Constitution, itching to issue opinions declaring unconstitutional congressional acts that made the Northern War effort possible. In particular, Taney focused on the Legal Tender Act and the Conscription Act. And in fact, he had his opinions already, ready to go, but just waiting for a case. And he had written out an 8-page opinion declaring the Legal Tender Act unconstitutional. And he'd written out a 22-page opinion declaring conscription unconstitutional. And if he could, then he would have stopped the funding of the war and mobilization for the war. The country was at a pretty dangerous crossroads, but Taney never got to issue those opinions on these fundamental matters because the court had only appellate jurisdiction. Taney had to wait, and by 1864 he died. But the opinions are sitting there in his desk, ready to go. Now, I don't think there's anything surprising in the Democrats' contention that conscription was unconstitutional. They just were going to raise questions about the Constitution, but it boggled Lincoln's mind as president. And he wrote a long document answering the Democratic position on this. It's a document he never issued. No one at the time ever saw it. It's not dated. We don't know exactly when he wrote it. And I might point out that it is not improper for the commander-in-chief to write out notes on this subject, as it was highly improper for the Chief Justice of the Supreme Court to make up his mind on a subject before seeing the case that might bring it up. So these two secret opinions are not equal. Well, Lincoln's document is called the opinion on the draft, but he didn't give it that name. That's the editors of his papers gave it that name. It has no name. And Lincoln was so convinced of the constitutionality of conscription that he could, all he could do was just sort of stab his finger on the document and say, look, it says right here. He wrote in this opinion, people who desire the rebellion to succeed, and others, he said, who might benefit politically by arguing that way, tell us the law is unconstitutional. Lincoln said, quote, it is the first instance, I believe, in which the power of Congress to do a thing has ever been questioned, in a case when the power is given by the Constitution in express terms. Lincoln could understand very well that there are arguments over interpretations of powers that are not expressly mentioned in the Constitution. But he went on and said, more or less again, whether a power can be implied when it is not expressed has often been the subject of controversy. But this is the first case in which the degree of effrontery has been ventured upon of denying a power which is plainly and distinctly written down in the Constitution. Now, there's no reconciling, you'll notice, these diverging interpretations of conscription, Tony's and Lincoln's, both in secret documents, and thank heavens they were never made public. There would have been quite a clash. Well, one thing we need to do is to try to imagine why Tony denied that conscription was constitutional. You'll notice it was hard. It only took him 8 pages to figure out the Legal Tender Act was unconstitutional. 22 pages of huffing and puffing on conscription before he could finally prove it was unconstitutional. And that's because Article 1, Section 8 clearly gives Congress the power to coin money, but says nothing about paper money being legal tender. And so that was something you could argue about. But Article 1, Section 8 gives Congress, says Congress shall have power to raise and support armies. It doesn't say you can't do it this way, you can't do it that way. It just says they can raise and support armies. Now, it does say that they can make no appropriation of money to that use for a term longer than 2 years. But that's the only limitation in the document. Well, how on earth could Tony have done this? Actually, Tony believed that it was unconstitutional for this reason. If the federal government had the power to draft men into the army, then it could draft men who constituted the militias of the states. And the militias are clearly mentioned in the Constitution. The Second Amendment to the Constitution says they're essential for the defense of a free state. And so if the federal government could draft all the militia, then it could abolish another military body that's clearly mentioned in the Constitution. Because as a matter of fact, the so-called militias in most states were every man of military age. So the manpower for conscription and the manpower for the militias, that's the same group. Incidentally, you'll notice that there's not much issue of individual liberty here. The issue is which government has the power of life and death over you, not whether government does. Is it the state or is it the national government? All right, that's some government has that power, and they're just arguing over which one. Well, I lived personally through an explosive period of debate on the draft, the 1960s and 1970s, and in that period, I carried on my person at all times a draft card from the time I was 18 to the time I was 26. I was interested in the draft. I listened to debates on the draft, and there were a lot of them. And you know, I cannot recall ever hearing the militia mentioned. So this tells us something, the second a point I want to make about constitutional conflict. And that is that constitutional conflict in the Civil War is arcane. It's often discussed in terms that are no longer of great interest to us. The fact of the matter is that conscription couldn't be brought up in court in the 19th century without also bringing up the subject of the militia. You know, that wasn't my lived experience, but that's the 19th century experience in court. Okay. Now, the Pennsylvania Supreme Court in 1863, for a brief moment before the personnel of the court changed, declared conscription unconstitutional. And the arguments they used were like the ones Tawney was using. I mean, they didn't know what arguments Tawney was using, but this shows you the way Democrats in opposition thought about the draft. The Chief Justice of the Pennsylvania Supreme Court said that if the federal draft could destroy the state's militias, that would, quote, leave the states as defenseless as an ancient city with its walls broken down. Nothing is left that has any constitutional right to stand for the will of the federal government. And another of the Democratic justices said of the militias, quote, "They are the security of the states against the federal government, their only security, for the states themselves are not allowed to support armies." So this image of the states as cities walled in for protection from the government in Washington, that shows you they lived in a rather different constitutional world from the one we live in. But that's how, at the constitutional level, the Conscription Act was discussed. Now, this is my third point. There were, of course, other ways to talk about conscription. There were problems with conscription beyond its constitutionality, of course. You could, under the Conscription Act, buy your way out of the draft by either hiring a substitute to do your fighting for you, or, in fact, by paying a $300 commutation fee instead of going. Now, there were lots of people recognized that there were problems with this, including some Republicans, and including a Republican who warned Lincoln about the problems. And this is Joseph Medill. Now, Joseph Medill was the editor of the Chicago Tribune, and he had known Lincoln back in Illinois. And in fact, at the moment we see him here in 1863, the time I'm going to talk about him, he had come from Illinois. He was sitting in Willard's Hotel across the street from the White House, trying to get in to see this man he'd known, back in Illinois, fuming. And here were all of to his mind, here were all of these office seekers, and here were all of these contractors getting in to see Lincoln, and he's sitting here in Willard's Hotel paying a bill. So he finally, in agitation, sat down and wrote out what he wanted to talk to Lincoln about. What he wanted to talk to Lincoln about was conscription. He wrote an 8-page letter about it, the Conscription Act. And he saw what many practical Republicans would see, and that is that the section of the Act which provided for conscripts to pay $300 commutation fee in lieu of personal service, that what that would do would be raise money and not men. Well, the government didn't need money. They needed men. And he warned them. He said, "You will get but few men under it, and they will consist of the poor, penniless, soulless, ragged loafer class, who have neither credit, money, or stake in the perpetuity of the Union." So remember that. Remember what Medill says about the people who will get drafted. All right. And then he pointed out to Lincoln that attempting to enforce commutation, quote, "will do your administration immense harm and cause it to lose all the state elections next fall. The Copperheads are gloating over the prospective harvest of votes they will reap against a bill that puts the rich man's dirty dollars against a poor man's life." Well, Medill, then it's an 8-page letter, right? So he has a solution to this, and that lies in interpreting the Act. All right? And he noticed that in the Act, the Secretary of War was supposed to appoint a person to receive the commutation money. All right? And so Medill said, suppose he don't. What then? Right? So Medill's idea was that the Secretary of War wouldn't accept the money and would leave unless the conscript just had a substitute standing right there ready to take money. But other than that, the Secretary of War wasn't going to receive the money, wasn't going to appoint anybody to receive it, and make the conscript go out and find his own substitute. This, Medill said, is the short, blunt, Jacksonian method of dealing with it. Well, in fact, then, he suggested a scheme, one of these elaborate schemes, in which the bounty would be paid, and then the conscript who wished to escape service would deposit his commutation money in a bank put in, he said, in a passbook at the office of the official in charge of enrolling substitutes. And then he would allow each volunteer to designate from among those depositing money for whom he would serve. Right? So the person who's going to serve as a substitute goes and says, I'm going to take the money from this particular person right here. Now, what's the point of that? The point is this, as Medill said. Republican volunteers will select Republican conscripts to become substitutes for, while Copperhead conscripts will have to find their own substitutes. By this means, the Republican Party will not have to furnish 3/4 of the soldiers as they did last summer, and thereby lost the elections in Illinois, Ohio, Pennsylvania, New York, Indiana, and Wisconsin. Lincoln didn't take the advice, of course, and he didn't really take the warning. So in this the document that he never issued, he goes ahead and makes what I would say is a good lawyer's argument for a bad client for the $300 commutation fee. And his argument, just briefly, was that it was true that substitution was objectionable, could be deemed objectionable as favoring the rich over the poor. But in fact, no one was objecting to that. He said what they were objecting to was commutation, and that, in fact, he said, put a $300 ceiling on the price of a substitute. So it helped people of lesser means to buy a substitute because it made the substitutes cheaper and shouldn't be criticized this way. Well, at this point then, I'll introduce my last character, who's Dennis Mahoney. He's from Dubuque, Iowa, the newspaper editor there, was arrested once by the Lincoln administration, which embittered him. Mahoney in 1863, he considered that his constituency was, he used the phrase more than once, the comparatively poor. And he was always thinking about the comparatively poor, and of course, being a Democrat, thinking about criticizing the Lincoln administration. So in 1863, he published a short book, which was called The 4 Acts of Despotism, comprising 1, the tax bill with all the amendments, 2, the finance bill, 3, the Conscription Act, and 4, the indemnity bill. And in this little book, among other things, Mahoney suggested that commutation be retained, keep that feature of conscription, but that it be graduated in proportion to the wealth of the draftee, so that someone worth, say, $1,000 could pay $300 commutation, and another person who was worth $10,000 would have to pay more. So he was going to graduate the amount of the fee, and that way serve the comparatively poor that he fancied that the Democratic Party served. And I will say another thing about Joseph Medill, though of course he disliked conscription and criticized it, as did the other Democrats. Back in Dubuque, when conscription arose as a threat to the people in their town, he helped devise a very complex scheme in which the local government would issue bonds, and then the money from these bonds would be put into a fund to pay $400 to buy a substitute for anyone who didn't want to go. And that was basically the Democratic answer to conscription. At the practical level, they would just set up a fund to buy out anybody who didn't go. And they did this, they said, they did this to serve their constituency of the comparatively poor. But of course, if they left the unwilling Democratic conscript at home, he could vote, just like a Republican in the bill scheme. Democrats never said that, but of course, it's a fact. And so that's really my last point about conscription, and that is at the level of constitutional debate, there wasn't a lot of light thrown on the issue. But if you looked below the level of constitutional debate, where the Democrats spent a lot of their energies, but below that level, there were lots of innovative ideas coming from the Democrats on ways to improve the conscription system. And the basic problem, you know, is really very simple. The potential federal draftees and the militia and the voters are all the same people. And you can't, in fact, the constitutional debate doesn't really help you sort that out very well, and you can't separate the political parts of constitutional debate from the question. They are inevitably. Okay, thanks. I think we have some time for questions, is that right? Or comments?
Yeah.
Yeah, sure.
On Connie's position that the draft would suck up the pool for the militia, doesn't the Constitution give Congress the power to nationalize the militia? And if so, that would destroy Connie's argument, wouldn't it? Because Congress, in fact, has the power to sop up all the members of the militia.
Congress can nationalize the militia, yeah, that's true. And as far as I know, he doesn't deal with that question in the opinion. I've never seen the whole opinion. I've only seen parts of it, excerpt. It seems to me it would. In fact, I mean, overall, that's my point. I think that the debate over the constitutionality of conscription, although it has a leg to stand on, that is, militias are also mentioned in there, and if the measure destroyed the militias, there's maybe wrong with that. But on the whole, I don't see a lot of. I think that Lincoln stating the Constitution was basically a good argument. I will say, if you look at the Federalist Papers, the papers on national defense, of course, are written by Alexander Hamilton. They're some of the very best of the papers. He wrote several of them. And he wrote them to what end? To prove that the powers of Congress to raise armies and the powers of Congress over these matters, those powers were, as he said, unlimited, without limit. But after he'd said that, for several papers in the Federalist, finally, in number 28, he does then say, well, people fear that this will lead to tyranny from the federal government. So can you imagine that in a country like this, where the states have the militias and could resist it, such a tyranny could be derived? So, in fact, Tony was closer to the founders than we are in seeing the states as walled off from the federal government and to be protected by their militias. So in that respect, he has, I would say, maybe some of the spirit of the Constitution on his side. Yes.
Could you recommend a source for learning more about who paid the fees and who don't and so on? How many men actually did that? Would you repeat the question?
Oh, the question is, can I recommend a source that would sort of tell how this practically worked? Right? But in particular, who paid the fees and such? I'm having trouble. Does anybody know what the source for that is?
D-O-R-R-I-S.
Jonathan Truman Doris? I thought that was about pardon power. No? What's that about?
I thought it covered the commutation.
Oh, does it cover the commutation?
Ivor Bernstein.
mm,
Ivor Bernstein covers the
well, he covers the
New York City.
He covers the reaction in New York City where after the draft riots, the New York City Council, which is almost 100% Democratic, votes $2,500,000 for to set up a fund for fees for anyone who's drafted. But he doesn't tell who did and who didn't. And in fact, I'm not sure. Anyway, I can't say. I don't know. So if someone does, I don't know.
If you give us your address, your email, we'll get it to you. There are a couple up here.
Other questions? I'll try to do better. Yeah.
Were the arguments used against the Confederate Conscription Act similar? It seems to me that it was a lot more extreme, where they conscripted entire regiments that were already in the field and said you're serving to the end of the war.
Yeah. Good question. And the arguments against naturally, the arguments against conscription made in courts or by pamphleteers in the Confederacy are precisely those. And that's not very surprising because the foundations of Confederate jurisprudence, much more so than Northern jurisprudence, the foundations of Confederate jurisprudence self-consciously are state rights. I mean, if you looked at a Confederate judge felt that was the peculiar role that a judge would have in the Confederacy, and that was to construe the Constitution according to state rights. Even so, no Supreme Court in the Confederacy declared the draft unconstitutional. None did. Jefferson Davis had it. Yeah.
When did the concept of absentee voting come in?
Oh, well, in the Civil War, of course, and we can. I see why you asked the question. I mean, obviously, there was considerable argument about the losses that the Republicans sustained in the elections, in the off-year elections of 1862, and it might be accurate, but certainly it was at least a convenient excuse to say, well, hell, all the Republicans went off patriotically to fight the war and let the Democrats at home to vote. And so a volunteer system won't take care of that because then they'll just keep on all the loyal patriotic Republicans will volunteer and all Democrats will stay home to vote. And so conscription is a solution to that. I do not adopt that cynical interpretation of conscription. I think it was rooted, each call for the draft, each one was sincerely rooted in needs for manpower, even calculated needs for manpower. How many we need, how many we've lost them, and so forth. And that this is at most a marginal consideration, but of course it's a consideration. So absentee voting is, with a couple of tiny exceptions, is a product of the Civil War. And a product of most of the state constitutions had a residency requirement. And so soldiers, if they were in the field, couldn't vote because they couldn't satisfy when they weren't resident where they would vote. So the Republicans worked very hard to change the state constitutions to amend them so that soldiers could vote in the field. They didn't succeed in every state, but in most they did. They couldn't, soldiers from Indiana, for example, couldn't vote in the field. Basically, it's a product of the Civil War and a product of this same problem, I guess, that the conscripts and the militia voters are all in here. Yeah.
Generally, one Congress can't bind another. I believe that's right. But is there any notion or any jurisprudence in any of these disputes, the different wars, as to whether a new Congress could repeal a declaration of war?
Help. I don't know. I mean, yeah. Paul,
I think the answer is that once a war is declared, you can only end the war through negotiation and a treaty, or through the president acting as commander-in-chief. I mean, it is what Congress can do, which it did in 1974, is cut off funding for the war. And if you want to end the war, you simply cut off the spigot and the troops come home. But Congress can't say the war is
Yeah, and so right here in this room, we have discovered another unwritten part of the Constitution, right? I mean, it doesn't say they can't do that, but in fact they can, can't they? Undeclared war.
No, and of course, the president doesn't need to sign off on the president.
Yeah.
Congress, it's not an act of Congress.
It's a declaration. Yeah.
So did Congress ever declare war against the CSA?
Congress, the Civil War becomes a war essentially by a court decision. In the Price cases, the Supreme Court.
They didn't recognize the CSA as a country.
Oh, no. No, they didn't. But there is a war declaration. Of course, it's a rebellion. And, that's how practically it's dealt with. But dealing with it practically, of course, would have been that they'd have to hang all the people they captured. It was just a rebellion, and that wasn't very humane. And so they deal with it partly as a war and partly as a rebellion. That's a very practical solution. Yeah.
The 13th Amendment includes a ban on involuntary servitude. I wondered if that idea was raised prior to the passage of that amendment or talked about at all. The idea of conscription being an oppressive measure against liberty.
Yeah, what is conscription involuntary servitude, right? Is that the idea? Well, I would say that pardon? I would, but no, the answer is no. As far as I know, that was never considered. And you can see, and that's a very important point, you can see that the debate, the constitutional debate between President and Congress and the courts, it's a debate over power, not over rights. Somebody has the power, life and death. It's just which entity. And so it doesn't seem very likely to me that that idea would arise. But there were all kinds of problems that came from service in the Army. So although what I just said is the case, I hope, on the other hand, the courts had long before the Civil War and continued during the Civil War to interpret military service as imprisonment. And so it was illegal to serve in the Army if you were under 18 without your parents' consent. But of course, Big Brother went off to war, and it looked exciting, or your father beat you and exploited your labor on the farm, and you would love to get away from that. And for various and sundry reasons, lots of underage soldiers volunteered and lied about their age. And it was, of course, a very unbureaucratic age, and so how are you going to disprove their age if they claim it? They're on a birth certificates. So a matter of if a 17-year-old or 16-year-old went into military service and it turned out, well, gee, this isn't quite what the glorious thing I thought it was going to be. Or his parents who wanted him back on the farm working, found him. They could get a lawyer, and the volunteer could ask for, seek a writ of habeas corpus, which the judge would issue to find out whether the soldier was underage. And the idea in the law was that volunteering for that your military service was a contract, and that infants couldn't enter the contracts. So if you were underage, it was illegal for you to be in the Army, and judges released them right and left. And that was a serious problem, and the Army fought that tooth and nail. And so in that regard, the law has I mean, after all, isn't it silly to think of military service as imprisonment? You know, prisoners don't volunteer to go to jail. Most of these soldiers volunteer, right? It's a really bad analogy. But at any rate, it seems to have been one that informed the courts. But as for your point, I don't know what's being considered. Paul, do you know?
Well, the problem is there's no conscription by the time the 13th Amendment is ratified, because conscription ends with the war, and you don't get conscription until 1917, and then the Supreme Court says in the selective service cases, no, conscription is not involuntary servitude, end of story. So they don't get, you don't get a ruling on it until World War I.
Yeah. Good way to end.
Yeah, very good. And go ahead. Karen tells me that she would like us to take a 10-minute break. And, so if we can be back by on that clock,